Good evening to Madam Bella. I'm Gerald Smith and I'm going to be presenting about leases and tenancies. So, what are lease and what are tenancy? Lease is an implied or written agreement specifying the conditions under which a lessor accepts to let out a property to be used by a lessee, while tenancy is a right that a tenant has to temporarily occupy or possess a real estate that belongs to a landlord, commonly under a lease. So the applicable law to both of these is on the lease is law of contract as regards rights in personam, NLC as regards rights in rem if the lease is registered. For tenancies is law of contract in personam, nor in rem rights as a tenancy is not registered. So another applicable law will be National Land Code, which only provides endorsement option for tenancy to bind new owner of premises if transferred during period of tenancy. So the difference between tenancy and lease, which we can see from section 213 1A of NLC, which is the duration of staying must not be longer than 3 years, and section 213.2 of NLC describe tenancy as tenancy shall be valid whether it is effected in writing or verbally by word of mouth, and if the tenancy is effected by writing, the instrument shall not be capable of registration. For lease, it will be fall under section 221 sub 3 of NLC, which says any period of staying longer than 3 years. The maximum term for lease will be 99 years if it relates to the whole of any land, and additional 30 years if it relates only a part of it, and only 30 years if it only relates only a part of the land. So the characteristic of a lease will be the lessee given the right to exclusive possession of the premises. The second one will be parties must have intended to create a lease and not a license. Lease must be for a definite duration, which is more than 3 years. So you can, as being described from section 221 sub 3 of NLC, and under the NLC, a lease must be registered. So sublease we can see from section 222 of the NLC, which states that it provides power to the lessee and sublessee to create subleases of the whole or any part of the land comprised in his lease or sublease. Section 221 sub 3A of the NLC provides where any sublease so granted relates to a part only of any alienated land, the term thereof shall not exceed 30 years. Section 222 sub 4 of the NLC provides every sublease shall be granted by an instrument in Form 15B, and in any case where sublease relates to a part only of the land comprised in the grantor's lease or sublease, there shall be attached to the instruments a plan and description sufficient to enable the part to be accurately identified. That's all from me.
Hi, madam. So, my name is Alicia Cassandra. I am going to continue on the effect of lease on third party. There are two types of lease on effect of lease on third party. One is registered lease and also the unregistered lease. I am going to talk on the registered lease, which under section 216 clause 1 clause A stated that the new proprietor will be bound by the express of or implied provision of the lease. The lessor is not obliged to obtain consent of lessee or tenant prior to transferring the land to another, but lessor should ensure that he does not breach the covenant for quiet enjoyment under section 232 clause 1 clause A.
Hello and a very good afternoon to madam. My name is Ivana Rachel and today I will be presenting about the effect of unregistered lease. So, as we all know that it is important to make sure that our lease is registered. If the lease is not registered, it is considered to be void. However, an agreement for a lease, if not followed by the registration of Form 15A or 15B under NLC or National Land Court, it will still create a lease relationship between the lessor or lessee, and the parties may sue for any breach of provisions of such lease. So such lease creates contractual right between lessor and lessee, but will not bind parties not privy to the lease agreement. Next is an unregistered lease therefore confers on Lee a right in personam, not a right in rem. Thus, such lease may stand as an equitable lease, and the aggrieved party may sue for specific performance, compelling the other party to register the lease. That's all. Thank you. Next, we move on to case law. So the case that we chose for this topic is Walsh against Lonsdale 1882. So basically, in this case, the defendant, which is Lonsdale, agreed to grant the claimant, which is Walsh, the lease of a mill for 7 years. The rent to be paid quarterly in arrears with a year's rent payable in advance if demanded. So the parties did not execute a deed for the grant of the tenancy, but the claimant moved in and paid the rent quarterly in arrears. So the defendant then demanded a year's rent in advance, but the claimant refused to pay. So the issues in this case is that the claimant argued that under common law rules, a lease had to be created by deed to be legal, and this had not been done, therefore the lease was not legal. However, the judgment of this case is that the Court of Appeal found in favor of the defendant landlord. The Judicature Act 1873 to 1875 had fused the two separate legal systems of common law and equity into one system. So, in any conflict, the rules of equity should prevail. That's all. Thank you.
To continue, I'll be explaining about lease versus a license. So the difference between lease and license is that lease creates an interest in the land that entitles leasee to recover possession of the land, and then leaseholders can bring forward actions in tort law of nuisance and trespass since they are in possession. So basically, lease is when they have ownership over the land or over the property, and when that happens, if anything were to happen, they can recover the land and claim it as their own. While license doesn't create interest in the land, but a personal obligation that is compensable on breach with damages. So it means that though you are not the owner and you cannot claim the property or land, but if there is damages or hurt or anything that causes any loss onto the land, you are obligated to compensate the owner of the land because though you're not the owner, but you do have a personal obligation to compensate the damages from the breach that you have because license is still like a contract. Then the next one is with a license, a person is granted the right to occupy premises with retained entering rights. With license, leases, you own that place or you have ownership of that property and you can enter at will, though there are limitations, but it is not like license where you are granted the permission or you are granted the ability to occupy the land, but that does not mean you can have all the entering rights because in a way it only limits you to a certain if you occupy that place Okay. License. With a license, a person is granted the right to occupy premises with retained entering rights. So it differs from leases, because leases you have the ownership over the property, so you can enter, or you have entering rights at will, which means that you can enter and you can go, or basically come in at any time you want, because you have the rights. But then with license, you have limited entering rights, because there's only so much that you are granted to do, or you have the permission to do, because that's the limit to license. Continuing lease, there are steps, or there are ways for you to breach or terminate the lease, which is under the National Land Code. There are three ways, which the first one is to forfeiture upon breach of provision by lease or bankruptcy. That falls under Section 234 National Land Code. The next one is the surrender of lease by lease, which is under Section 239. And the last one is to the determination otherwise by surrender and forfeiture, which falls under Section 240. We'll start with the first one, which is forfeiture upon breach of provision by lease or bankruptcy. This means that the contract or the agreement of that lease will be terminated or forfeited when there is a breach of provision, when you cross certain rules that you weren't supposed to do and you breach, and from there results in damages and hurt. Or aside from that, it can also be because you are going bankrupt, or there is insolvency in your financial statements or financial crisis. So when those two happen, automatically the lease is terminated. The next one, which is under Section 239, is the surrender of lease by lease. So when that person doesn't want to have ownership of that land anymore, they can surrender the lease to the original owner, or to the rightful, or to the person who actually has the ownership. You can surrender and give back the land, so that you don't have any ownership over it, and the contract or the agreement can be terminated. The last one is determination otherwise than by surrender and forfeiture. Determination here means, or is defined as the termination of lease. A lease or a tenancy under the National Land Code, revised under 2020, is determined in four circumstances, namely upon surrender of the lease, as I mentioned just now. And then the next one is the expiry of term under the Section 240 of the code. And next one is the services of a valid notice to quit. And then the last one is the forfeiture of lease under Section 235 of the code. So that's basically it for the termination of lease.
Assalamualaikum and hi madam, my name is Nushafia Nadira binti Jacob. So today I will presenting on the case law that relating to the characteristic of the lease, where it was under the exclusive of possession. Okay, basically the case is the Westminster City against the Circuit 1992. Okay, basically the fact of this case is where the Shakli, which is the C, known as the C, was occupying a room at a hostel that was run by the Westminster City Council, and it was intended for the homeless person. As per the regulation of the hostel, no occupancy was entitled to any particular room, and future the hostel was entitled to require the occupants to share a room with another occupant, and then they forbid visit for the non-occupant, and unless have permission was granted by the owner, and also its staff only can be entitled to access any room with this anytime and anywhere that they want. And for the judgment, the court was held that the household was held that the determined that C claim for the tenancy was incorrigible with the totally imposed on any given occupant, such as C, and he had no right of possession. So this right is for the owner, which is the council who has the hostel, and the council also was entitled to do so in order to supervise and control the activity of the occupier, because he is the owner of the hostel, so he can do anything what he want to do. So this is for the case under exclusive possession.
Next is the effect of tenancy on third party. So there are 3 points here. The first one, if an endorsement is made, the tenancy will bind the new proprietor. Without the endorsement being made, actual or constructive notice is immaterial, as it shall not bind the new proprietor as per section 213 clause 3. And in a judicial sale, tenancy created prior to the registration of a charge, but not endorsed, hence will not bind the purchaser as per section 267 clause 2. In the case of Tan Kok Leong against Low Kim Hai 1983, so the fact of this case, the plaintiff purchased premises from Patricia Pereira. The defendant was a tenant that pays $950 per month. Plaintiff issues a notice to vacate, which expiring on February 28, 1978. The defendant refused, as he claims that an oral lease agreement with the former landlord for 3 years from January 1, 1978 exists as with a renewal option. So the issue of the case is the validity of oral and unregistered lease under National Land Code, and also the applicability of equitable notice and specific relief ordinance in Malaysian land deeds. So the judgment of this case is that the oral agreement of the 3-year lease with renewal existed. Under Section 213 of the National Land Code, the oral lease was not binding on the plaintiff, and Section 228 Clause 2 rendered the option to renew unenforceable. Equitable notice in English law does not apply in Malaysia, which is the Section 6 Civil Ordinance 1956. Section 26 of the Specific Relief Ordinance 1950 also does not apply to the torrent system. Hence, the defendant's counterclaim dismissed with cause.
Coupled with equity. Basically, what is tenancy coupled with equity? It happens when a tenant takes possession of the land under an expectation, faith, or any sort of like encouragement from the landlord. But it has to be created or encouraged by the landlord that he would have a certain interest therein towards the land, and expends money upon the land, uses his own money towards the landlord's land, based on the expectation, faith, and promise. Similar to equitable estoppel, it's invoked by the tenant as against a landlord who later denies the existence of tenancy to extort from irrevocable. Basically, it means that when you are acting upon the faith or expectation of the landlord, so you're spending money on this land, but then when you either want to occupy or stay there longer, the landlord suddenly denies you and says that there was no such expectation, faith, or promise. So tenancy coupled with equity is what is going to be invoked so that you can remain on that land, because it binds the tenant to be able to remain on the land, as it raises equity in the licensee for his entitlement. So he is entitled to that land because he has spent money on his land, because of the encouragement from the landlord. Such expectation, faith, promise is also binding on successor in title and purchaser with notice. Also to note that for tenancy, it is exempted from registration and also not counted as a dealing under section 223 and 213, subsection 1, and then section 213 subsection 2 subsection B of the National Land Court.
Hi, my name is Ainin Sofia. I'll be taking over to explain an example case about tenancy coupled with equity. So, in the case of Davy versus Francis, the plaintiff, Davy, was the widow of the deceased, Francis. She filed a suit against the defendant, Francis, who was the brother of the deceased. So the plaintiff claimed that the defendant had wrongfully taken possession of the deceased property and assets, including a house, a car, and a bank account. The plaintiff argued that the defendant have no legal right to the deceased property, that it should be returned to her as the heir of the deceased. So the defendant claimed that the deceased had gifted him the property and assets during his lifetime, and that he had a valid reason and claim to them. So the court had to determine whether the defendant had a valid claim to the deceased property, or if it should be returned to the plaintiff as the widow. So the court ruled in favor of the plaintiff, Davy, and ordered the defendant to return the house, the car, the bank account to her as the rightful heir of the deceased estate. So the case highlights the importance of proper documentation and legal procedure when transferring property, because especially in this context of inheritance and succession, it also emphasizes the need for clear communication and understandings among family members to avoid disputes over the deceased's assets.
Now I'll talk about tenancy by estoppel. Just now we talked about how it is invoked when the landlord is denying the tenant. So we talk about that. But this one is like now terbalik. So this is when the landlord is using this estoppel. So the landlord is the one invoking it. So tenancy by estoppel is a lease of land by estoppel is when the grantor or the landlord has no legal estate or title or interest in the land at the time of the grant, but claims to grant a lease or tenancy. The tenant of immovable property during the continuance of tenancy shall not be permitted to deny that the landlord had title to such immovable property that is under section 116 under Evidence Act. But basically, in short, it means that the principle is invoked by the landlord against the tenant, because just now we talked about the tenant against the landlord. Now is the landlord against the tenant. So it's basically the opposite of tenancy coupled with equity. That's all.
An example case for tenancy by estoppel, the case of CTI Leather Sdn Bhd versus Ho Ju and Khoo Hock Tat and others, and involving the allegations of breaching of fiduciary duties by the defendant directors towards the plaintiff company. And the liquidator raised complaints regarding various actions by the directors, including causing the plaintiff to purchase items at inflated prices. So by renting premises to related entities at undervalued rates and disposing of low stock values. So this resulting in significant losses for the plaintiff. So the court investigate that the action of the directors, highlighting instance where despite resignations, Director maintain control over the company's financial affairs. So this indicate the directorship responsibilities and the potential breaches of fiduciary duties. So the case underscores the legal implications and liabilities associated with the directors and the importance of upholding fiduciary duties towards the company. So even in cases of resignation or nominal roles within the organization, it's important for you to understand how the company works.
Okay, moving on to the next slide, this is the detail that should have in the lease or the rental agreement, which is of course first thing first should have the name and the contact information of the owner and also the tenant. This is because we want to establish and know the identity of the parties who was involved, who are the owner and who is the tenant. So it also can be used when there are some emergency cases who was occurred such as like the natural disaster like the tsunami and so on. So if the emergency issue was occurred, so we can know who we can contact and who we can be informed to. Okay, for the second point is the lease and the type of tenancy. Okay, basically this one is the duration and like the term is the fixed term, is it the month or 2-month agreement, or is it year-to-year agreement? Okay, basically nowadays if we want to rent a home or any room in Malaysia, of course we should do an agreement at least 1 year with the owner. Okay, for the third point is cost of rent, amount of the security deposit, and the term of the payment. Okay, basically this one is to avoid the misunderstanding and dispute between the owner and also the tenant, and it was include the amount of the rent, like how much we should pay for this month and how much we should pay for next month. Is it the same for this month, and is it the price will be increased in the 3 months later? And by this agreement we also can be know when the due date, like is it the early of the month or the last of the month, or how we should pay, like by online banking, or we should pay by the cash and so on. So moving on to the next point, which is the responsibility for utility payment. Okay, basically the utility was include like the electric, like the water, gas, Unify, Wi-Fi, and so on. So basically this is to prevent who will be paid for the utilities. Okay, moving on to the next, which is the additional fees for parking and maintenance and also repair. Okay, basically this is the extra cost that may be surprise to the tenant. Okay, basically tenant always think that, oh, we rent this house, so of course we get the parking. Okay, basically no. If we rent a house or apartment, we should pay the additional for the parking by monthly or yearly. Okay, we also should pay the maintenance for the common area, like the lift, like the entrance, and so on. Okay, moving on to the next point, which is the damages and alteration to the premise. Okay, basically this one is if the tenant do some damages to to the house or the property, they should uh, alter it or modify it to be as like the owner was giving to them. Moving on to the next, which is the renewable determination. Okay, basically this is a procedure, the lease, where it helps the both party to know the future when the lease was end, when the lease was continue, so we can know the next step, which is if the owner know the tenant will be get up, of course the owner will find someone to get into the properties, something like that. Moving on to the next point, which is right of entry and also the security deposit. Okay, basically the security deposit, of course, nowadays we should pay because it is fairness in for the owner or tenant in case of such as the damages was beyond to the house, and then the tenant was not repaired, so the owner can use the security deposit in order to repair the house. And the last but not least, of course, we should sign all the document that we have been do. Of course, the both party, the owner and the tenant, should sign the agreement at the back of the papers. So that's all for the item. Okay, moving on to the next slide. So this is the example of the agreement, which is the left one is the lease agreement and the right one is the tenancy agreement. So basically both of these should have the detail that I have been explained in the previous slide. So you can see here the details, all the details was included in this agreement, like the name of the owner, the signature, and the term of the contract, and so on. Okay, in the conclusion, basically the lease and the tenancy is the typical involved to ensuring the properties is to return in a good condition, to settling any outstanding payment or fees, and to finalize any necessary paperwork such as the written security deposit and so on. Okay, basically the lease and tenancy also can bring the benefit such as the opportunity to the landlord, like the landlord can find the new tenant at the potential the higher rate, and also for the tenant can explore the new living agreement or the location that suit to their needs. So actually this lease and tenancy was allow the both party to settle any standing issue and also move with the clarity and also closure. That's all from us. Thank you so much.